Good morning, afternoon, everyone. Welcome to the Do More With Your Money podcast, episode 180. Bullseye, Neil. How to write your will is the topic today. We're joined by some old guests, not in the sense of being old, but in the sense of being here quite a bit, and some new guests as well. So, welcome. We've got Neil Rayner, Head Office Advice, Daniel Harrison, Chief Executive Officer of True Potential Group, and Susan Maxey, who's a guest speaker from Womble Dickinson. Good morning, Susan.
Good morning.
I think in true Potential style, if you could introduce yourself and tell us a little bit about what you do.
Sure. Yeah, Susan Maxey, Legal Director with Womble Dickinson in the private client department. So having qualified as a solicitor back in 2001, I've spent my entire career advising private clients. So that's really on wills and the whole range of estate planning issues.
Excellent. And I think, as I said, the topic today is how to write your will, which is why we thought we'd bring an expert in. But also, you and Dan have been working together a little bit over the last few weeks. So I thought it was quite pertinent to bring Dan and have this life experience.
I'm today's live case study, so please feel free to pick on me. Susan, Jamie and Neil. Jamie and Neil pick on me all the time anyway, Susan, so you may as well join in.
We try. Yeah. Let's get straight to it. I think from a will perspective, we've always said on the podcast over many years of how important that is, and part of giving financial advice is if someone doesn't have a will, you do have to recommend that they do have one. I suppose the big question is why is it important to have a will?
Yeah, I think the main reason is to ensure that your assets, whatever you own, actually end up with who you want them, where you want them to go, who you want to receive them. The intestacy rules, that means when you die without a will, don't necessarily mean that your assets will end up with who you want them to go to. And that's particularly the case, for example, if you're not married. So if you're not married, it's not the case that if you die without a will, it will go to your partner. That doesn't happen. There's no such thing as a common law spouse, but it's a bit of a myth. So in order to ensure you get your assets to where you want them to be, a will is really the only way of doing that.
And how often is that something you come across quite often, where people aren't married and this is something you have to have a discussion and they don't realise that actually their assets aren't going to be passed across?
Absolutely. I think especially in today's society, cohabiting is really common. And therefore it is a real issue for many people, and really looking after their partner is a really important thing. I think also what's really common in today's society are blended families. So that's what I mean by that, families where there are children from different marriages. And again, if you were looking at the intestacy rules, then those different children wouldn't necessarily benefit in the way a client would want them to.
So it's interesting. It's key. For me as an individual, I have a will and I set one up a few years ago after having a similar discussion with someone like yourself. I'm married. I expect that typically the common thought of that is that 50% of my assets 100% of my assets, not 50, will go to my wife and children.
You've got an extra wife
somewhere. Don't tell her. But no, that would be my common thought if I didn't write that up. But that's not always the case.
It's not always the case, so it depends on the value of your assets. So without getting into the technicalities of the intestacy rules, depending on the value of your assets, the entirety of those assets might not go to your wife or husband. It may be that only a proportion goes and the rest are reserved for children or other family members. So again, making sure that your wife is fully protected, really a will is the only way of doing that.
And Dan, why did you, what got you thinking about this is what I need to do? Was it an update or was it a...
It was an update. I was long overdue. So my last will was 10 plus years ago.
So it was really pre-children, I suppose.
Prior to children, lived in a different house at the time, etc. So it was, it's a classic case of, I think all of ourselves, probably in here, we always leave ourselves to last as well from there. But the children was an important thing because I think, as Susan said, it's yes, the asset transfer and where you want the assets to go is so key. But what I also needed to navigate, say, with Susan was if me and Gemma pass away at the same time, God forbid, let's say there's a car crash, it's what happens to those assets with the children, what are going to be our wishes. But importantly as well, I think, how do we want the money to go to the children and when? And if we pass away before they're 18, who do we want to look after them, and how do we want them to be looked after as well. So I kind of think we've just been interested, and just see Greg in the background there, because Greg's just had a little girl, and he's set a will up, but he hasn't thought about any of that yet. He's almost done what I class as the boilerplate will, which is the asset transfer. When I pass away, my wife will get this, and if that, then that. But I think there's a lot more intricacies from it.
Yeah, so have some control now where you don't have control in the future.
I think it's control. I think it's a subject nobody wants to think about. You know, we used to laugh about this with you, Jamie, at seminars where we said Jamie will probably live forever. By the time medical science, it is scary, but you know, with medical science. But unfortunately, people do pass away when they're not expecting it, which I know sounds like a silly thing to say.
Well, we were joking about it before, and I think what I said to you was just tongue in cheek, was a lot of people think they're too young to have a will.
Yeah, absolutely. That's really a really common thing. You know, aren't wills are something you do when you're later in life. You sort of, you know, much later on. But actually, as we know, sadly, death can come to any of us at any time, and none of us know when that is going to be, which is probably a good thing, to be fair. But what it means is that, you know, the more you can do while you're here, while you're alive, to get your affairs in order, the better. And bluntly, not only the point about the intestacy rules, but actually it's just really hard for the family that's left behind to navigate an estate without a will. It's just administratively more difficult. So you're actually just leaving your family with a bit of a headache.
I've experienced that before. I helped an elderly auntie out where there wasn't a will in place. Husband died unexpectedly, as you'd expect, and he had money in all sorts of different places. And actually, what was becoming very difficult is we had to get the children to sign over some of the assets to back to the mum.
Right. Okay.
Because they got to that being complicated. So, and it was an easy process. And I'm not exaggerating here. 2 years later, we were still trying to resolve.
Yeah, absolutely.
So I think that was the key moment for me, really, where I thought I need to sort this out for myself.
And at a time for the family where it's the worst thing to do.
You know, they're devastated, they're grieving, and all of a sudden they've got all of that to sort out. And I think, not that I want to dwell on costs, but sometimes cost of making a will might put people off. But actually, if you think about that scenario and how much it would cost to unwind and deal with an estate where there hasn't been a will, it actually in the long run would have been cheaper to do a will.
So how do people go about this? I know there's obviously will companies online that you say. There's a lot of, like, what would be the most appropriate way if I wish to settle a will as a client?
Yeah, so, I mean, obviously as a solicitor, I would always say go to a solicitor and go to a properly experienced and qualified solicitor to do a will, because on that basis you will get the best will for your circumstances. I accept that everyone's circumstances are different, so what might be right for one client won't be right for another. There are a lot of unregulated will writers out there, and I would just say beware of those, because they are unregulated. And they're not necessarily in a position to do the right will for you, to understand your particular circumstances, to produce the right document. And actually, there's potentially a lot of hidden costs in that approach. In fact, the Competition and Markets Authority is actually investigating unregulated will writers at the moment, because there's some concerns about consumer protection in that scenario. So I think my advice would always be to go to someone properly qualified.
I'd back that up 100% as well, Susan. Again, just selfishly using myself. Having you as a professional advisor, as an expert advisor, was superb for Gemma and I, because, you know, there is, going back to what we said, you never want to think you're going to die, and it's hard work thinking about it, and you obviously give us some homework to do, and like we could never quite get our head around the homework about, like, well, what do you want to happen here, what do you want? And it wasn't until we actually sat with yourself and you could tease those answers out of us a bit to get us to think in black and white sense and then write it down. That helped. And I couldn't do that on the internet. I couldn't go onto a, willwriter.com or whatever and think. And I well, you might disagree, Susan. I don't think I'm particularly difficult in our setup. You know, Gemma and I and 2 children. We own our own house. We've got some financial products underneath, and that's it. It's not as if we've got something tucked here and something tucked away there. And getting good professional advice, very similar to what we say at True Potential. In terms of your financial affairs, you should certainly be doing the same with your estate affairs.
Was there any questions that you asked Dan as part of this will process? You went, wow, I didn't think of that. That wasn't something I was
probably going back to some of the kind of the attorney side of things, in terms of if we pass away before the children are 18, it's who do you want them to look after them? It's things like that, and
that can cause some animosity across the family.
Yeah,
I think
so you're right. So it's guardians. So and back to, it's a really good point that you make about that's often when people decide to make a will. So they have a child or children, and what gives them the impetus to make it is, well, who would look after them? And there's one issue around the finances and how the money would be managed for them. But the other bit is, well, actually, what about their welfare? Who are they going to live with? Who's going to sign that school trip form that says they can go off and go and basically step in your shoes as parents? Who's going to fulfil that role? And quite honestly, that often stops people going ahead with will because it's too difficult.
It becomes like a logjam.
It's a really that's a tricky one, isn't it?
Because obviously the common assumption would be you'd say, oh well, my mum and dad would look after, or your brother or your sister. In your case, Jamie. But like, if I think about my own parents, they're, Dad's 73-year-old now. The last thing he wants is a 9-year-old and a 7-year-old. And it's some of that is exactly as Susan says. What are your wishes in terms of that? Are you going to give them financial support as well? Because you get lumbered with a 9-year-old and a 7-year-old with no financial support. That could be a good hand grenade for whoever you select.
It's a good question what you said before. When we start the financial advice process, one of the questions that we ask is, do you have a will? Because that can have implications from a tax point of view, inheritance tax point of view, which is sort of all brought together, isn't it?
Well, let's talk a little bit more about that, Neil, because obviously it depends on the asset that you have. We recommend a lot of pension work as well as investments. What would be from an inheritance tax perspective?
Yeah, so as we know, quite commonly, I think, obviously in our world, but a lot of clients don't know, so we sort of keep reiterating it when we do financial reviews, is pensions are generally outside of your estate for inheritance tax. There are limits to inheritance tax that we have, but certain products are exempt from that. You do have products which aren't exempt, such as ISAs or general investment accounts or cash in the bank. But there is an inheritance tax limit of £325,000 per individual. They can qualify for an additional £175,000, which is if they leave their main residence, to their direct descendants. So a couple could have £1 million worth of cover. And when we're talking about pensions, assets in a pension are generally exempt, as I've just said, from inheritance tax. But then there's also good planning that you can do with a pension. We talk about beneficiaries within a pension and how you can pass it down further down the line to generations. So that's a really important point which we pull out in the financial review.
And presumably you do expressions of wishes or whatever with regard to the
pensions. We have a big push on beneficiary pensions because using our technology, we've incorporated it into our technology now, so it's very, very easy to tell us who your beneficiaries of your pension are. That's great for us, so we keep it on file. And then also as well, we inform clients of the taxation rules upon death, and so
it's interesting the nomination of beneficiary on a pension, because obviously your pension will sit outside of your estate. So from a will perspective, that actually can be sorted out pretty much overnight.
Yes.
But it's at the discretion of the trustees of the pension scheme. And what we find a true potential, we're incredibly pushy on ensuring we try to get in a good way, because we think it's beneficial to the clients, is about getting a beneficiary written down as a nomination, because when it comes to the awful day where they have to do that, then actually we can ensure that it goes to your loved ones. Looking at our client bank as a whole, looking at our customers, we're pushing nearly 85-90% of people have that written down, but not everybody. And I would always implore people to do that.
Well, it's not everybody, and it's exactly what Susan says. If you don't get your wishes written down, you can get stuck and it can get messy. And as trustees, because we are the trustees of the pension scheme at True Potential, as well as people like Mark, for instance, and Richard Taylor. Unfortunately, there's still cases 2-3 times a week where there's not a beneficiary, and then it's just yet another kind of frustrating conk for the family then about being able to unlock.
Yeah, because that will inevitably cause delays, and because the probate process from a legal perspective can take quite a long time. The pension can be a really important resource outside of that process.
Yes.
So enable the family to get their hands on some capital early.
Yeah, I think the reason why we pushed a lot on the beneficiary side as well was because upon death of the policyholder or the pension holder, a lot of clients thought they just had to take that money out of the pension, which it could be really used as a really good income tool in the future for that beneficiary. So it's knowledge as well. So when people come over to you and say, I'm thinking about getting a will, or I don't have a will, and they don't have a clue about intestacy, they don't have about who legally it goes over to. So I think it's an understanding that we give to the client and what you can and can't do.
It's interesting point that with just going back to your point there, Susan, about around timings there. So what's or is there any difference if I had a will set up? Is that a quicker process for somebody in terms of getting the estate moved across, and if I didn't, like what could be the potential timings being if you didn't set
I
it
think
up?
it really depends on an individual client's circumstances, how complex their assets are, and what's in there to deal with. Some, if it's an extremely straightforward estate, can be dealt with in a matter of months. Others will take, a couple of years if there's a vast amount of assets and complexity. So it really varies. And to an extent, you are in the hands of the probate registry ultimately.
Yes.
But that would be the same whether you were, if you had a will or didn't. But I think it's probably the point make there is relevant in terms of how you own assets. So if you own assets jointly with a spouse, say, so we've talked about the family home, commonly a married couple would own that jointly. Without getting too technical, there's two types of joint ownership in English law, but the most common for married couples means that on death that asset automatically passes to the survivor, irrespective of what the will says. So in a way, some assets will move very quickly without the probate process because they're jointly owned. It's the assets that are owned in a sole name that will take the time and have to go through the probate process.
So that might be a consideration as well as a will, is how your assets are jointly.
Absolutely. And we had this discussion, didn't we, Dan? Do you own that in your sole name? Is it jointly with Gemma? Let's have a look at exactly how you own that, because that will dictate ultimately how it passes.
That's interesting, isn't it? Because sometimes you purchase things because you don't it's both ways across my family. Sometimes Annie will buy the car, I'll buy the car, whatever.
Well, it's even if I think about my own investments here, some of which I own jointly with Gemma, some of which I own solely. For instance, which then takes on to some of the further discussions I've been having with Susan about what goes to the children versus what can go to Gemma. Sometimes if you've got the solely owned things and you use trust, you can use different expressions within there. I can say, well, this money here goes to the children only, not to Gemma, but to, and you can then obviously use all the intricacies in terms of ensuring Gemma's never left on the street, for instance. There's enough money there.
Or when the kids get access. At what
age? Which is probably a step somewhere on this paper here as well, which is again something which I haven't quite squared off yet with Susan and Gemma about what age the children get the money as well, because again this probably is could be some of the issue with more boilerplate wills, I guess, and as far as they get everything at 18. Now you might say, well, that's okay, like they're 18, they're an adult. But if you think back to yourselves when you're 18, let's say you get a lump sum of £10,000, £100,000 or whatever it is, and you're 18, that could go very quickly. And that might be fine. You might say, I don't care, I'm dead. But ultimately you might say, no, I want my children to be happy and looked after. I might want some of that money to go toward buying a house or paying towards university or whatever it could be. And I think that's where some of the trust work which we're doing now is really important.
It's about protection at the end of the day. And then moving on to the children, none of us like to think that our children are going to go off the rails when they're adult, but who knows? And they develop a drug habit, or they spend it on a Ferrari, or do you really want that? And 18 is very young, so it's about asset protection, really.
It is, and that goes back to the advice point I said before. These are things I don't think you'd consider.
No.
looking on the internet.
It's the questions that you probably pick out that you've seen at the far end
exactly
to ask at the front end.
And it can make me seem like I'm being cynical, or I don't want my wife to get, and it's not that at all. It's exactly as Susan says. You want to ensure that if you're not here tomorrow, A, your spouse is well looked after, but B, your legacy continues and your children are looked after.
It's a peace of mind thing, isn't it?
Yeah.
To ensure that you're also getting all bases covered by a professional. And that you're not getting a standard, off the shelf writing service.
And I think that probably that peace of mind's a really interesting point as well, Neil. Goes back to what we said earlier, which is I feel healthier. I don't think, hopefully I'm not going anywhere for a long time, but and it's probably a bit of advice on me, do it sooner rather than later, everybody, because if you don't, imagine you become poorly, and I sound real doom and gloom. You're poorly and the doctor says you've only got a month to live. The last thing in your mind, you're not going to be thinking straight, and you're not going to be thinking some of what, and this has taken us a couple of months, longer now, to work through some of this, because these are longer term decisions from there, and we all know what it's like when you've got to make hard decisions in a short frame of mind. When you've got other things going on, you can become blurred in your thinking, and so it's when you feel good, when you feel healthy, when you have the time, do it.
That's right. And for younger people, do it, and you can stick it in a drawer and leave it, and really just review it maybe every 3 to 5 years. Or if something happens, like a child comes along, or there's a marriage or a divorce or whatever it is. Actually, just on the marriage point, not many people know that marriage automatically revokes a will. So basically cancels the will. So, you make a will, you go off and get married. The act of marriage basically makes your will null and void. So a lot of, that's a big thing that people often don't know.
So even if you'd set up your will to give it to your partner anyway, you get married, it's effectively...
Correct, unless you include particular wording, you're going to get married, so you do a will in anticipation of marriage, and you include some wording in the will that says I'm making it in anticipation of marriage. If the wording doesn't include that, or the will doesn't include that wording, then actually the will is revoked on marriage, and you would, if heaven forbid something was to happen on the honeymoon, we really are doomed to then you would die intestate. Again, it's those things, it's the major events in life that should cause you to review your affairs.
I think a couple of final questions, and then we'll conclude. I think from my perspective, so how often should I do it? So I've done my will. Dan's just talked about there. It's took me 10 years to get round it again. That sounds not as organised as you normally sound, Dan, to be honest. But how often should this be something I should review as an individual?
Well, like I said, I think it probably 3 to 5 years maybe is what we say to clients generally. Obviously, if a client is ill or elderly, I'd probably encourage a bit more of a regular review. Or, as I say, if there's a major event in the family, it's cause just to check the will, because often people forget what they've put in the will and time moves on, and then they look, I didn't realise I'd done that. So,
and it was a great point what Dan said before. If anything happens to you and you said, God forbid, I've got X amount of months to live, you're immediately put into a vulnerable position, and you're a vulnerable person. And like Dan said quite clearly before, you're not thinking straight. But also as well, if you were in that state and you went over to somebody yourself who's a professional, they would take a lot of stress away from that individual as well, which is really important.
Great. One final question then for me. So we write a will, we get it together. Where do we put it? Who stores it? How do we know it comes out in the future?
So again, that's a really good reason for instructing a solicitor, because a solicitor would offer or should offer to store the will for a client free of charge. That's certainly what we would do at Womble on Dickinson, and keep all documents together, both in hard copy in our archives, but also store it electronically as well for easy access. That is really the best way of doing it. Obviously, if you do it online, well, it's your responsibility to work out where to store it. Obviously, keeping we always send clients copies to store themselves with their own records, and we do encourage clients to inform their family where they've done the will, which solicitor have you used, where can they find a copy, just so that there's no mystery when the inevitable happens.
We used to recommend a lot, Jim, and we don't talk about it too much now, is even in your client sites, you've got a secure document vault there as well, so just keep an electronic copy there means you can access it anywhere in the world, and it's in an encrypted environment. God forbid if you were to pass away abroad or something, at least you can access those documents straight away in tandem with using your solicitor for it.
We were looking at and something we've been looking at from a technology perspective is now we're looking at beneficiary websites for our clients, so they can they know that, for example, they're going to inherit someone's pension, but not necessarily the value of it. So it's an area that we start promoting to clients, and many have already signed up for this. And this is something that we could potentially look at, which is storing documents, on death, such as wills.
You may not want the beneficiary to see your will in case you get thrown down the stairs, Jamie.
But maybe it's on death, who knows? But never know.
We have documents like that, like the power of attorneys, which are kept on files now as well.
I'm going to go home tonight, in fact, because I think my will's in a drawer somewhere.
And you're moving house.
Exactly.
That drawer might end up somewhere else.
Just thinking I said I did it a few years back, and some of the questions I go through, I was very I hadn't thought of it. That's why I think it's really important to speak to someone like yourself, Susan, because it's interesting. You just think everything's just going to happen and money's going to move to your loved ones, but if you don't designate it at this point, it can be really difficult.
It's peace of mind. It's Susan was saying before about the cost of it. Hopefully it's the best waste of money ever. You pay the money and it sits and and it's not accessed for many years to come. But just go by that worst case scenario that all of a sudden you become poorly and you want to spend time only with your family and spending quality time. You don't want to be having to go to the solicitor's office.
And it's where your priorities totally change.
Correct. So it's
a good point.
It's peace of mind, I think, is invaluable.
Should make sure you put your suits in the will for me, Dan. We're similar size. I know you wear good suits.
You're bigger than me. Broader and taller, Jamie.
You can go for his suits. I'll just go for his cars.
Right. Well, thank you, everyone. Really interesting, and Susan, really appreciate you coming in today. I think it's actually opened my eyes a little bit. It was 3 years ago, so I've got a couple of years. I maybe need to have a look at that and find it. But hopefully that was useful for all our viewers today. Please like and subscribe, and we'll produce much more content like this. Watch the Morning Market videos as well if you haven't already signed up for those. But thank you very much, everyone, and thank you. Have a great day. Thank you.